Okay, we can proceed with the rights and liabilities of members. So these are the basic rights of the members of any company. That is the right to be sent a proposed written resolution, the right to require circulation of a written resolution, the right to require directors to call a general meeting, to receive notices of general meetings, to require circulation of a statement, to appoint a proxy to act at a meeting. When you get notices of general meetings, you also get forms to appoint a proxy to vote for you, and the right to be sent a copy of the company's annual financial statement and reports, as well as if the company is a public company, the right to require the circulation of a resolution for the AGM of the company. These rights of members, they're set out in the Act, so companies do not have much to say about them, and they're followed to the letter. You see, you cannot have a general meeting without notifying the members that a meeting will be held, and you circulate the agenda of that meeting. When you are also notifying the members of the meeting, you will attach the proxy forms, and whereby you give the members the option of having someone represent them, and not just represent them, but also vote on their behalf. The company's annual financial statements and reports, more often than not, will also be availed. And if they're not availed, they'll be available in the company's website. And in a public company, they're published. So these rights of members under the Act, not much can be said about them because they have to be followed. You see, a meeting cannot take place without a quorum. The resolutions cannot also be passed without a quorum. And whether it's a special resolution or not, again, the members must be made aware. You remember we talked about the articles of association, and where we intend to change a company from a public to a private to a company, to either limited by guarantee or shares. Again, the members must have been given a chance to go through the resolutions, and those that have any issues are also given a chance to present their issues. It's their right. There's nothing much to be done or said against that. But now we have specific rights of members, and these are the rights to dividends, as well as the right to company investigations, and the petition for winding up and preemption rights. So the right to dividends, you remember that a company does not legally have to declare dividend, and only directors can propose whether it is to be paid. And if this happens, the shareholders may vote in favor of it. And once a dividend is approved, all shareholders are entitled to payment. So you'll have instances whereby the company may not declare, probably because if they have losses, they have nothing to distribute to the members. But this information will be made public. And this is where we were saying the right to be sent a copy of the company's annual financial statements and reports. It is in these financial statements and reports that a member is supposed to study and examine in preparation for any meeting, whereby they will be told whether the dividends will be proposed, and the members vote. And once the members, the votes are tallied and agreed, then the dividends can be shared. So another specific right is that of a company investigation. So a minimum number of company members can ask the High Court to appoint an inspector to investigate and report on the company's affairs. So where members may feel that the affairs of that company are not being run as per what is agreed on in the memorandum and articles, they can petition the High Court to order an investigation. And the court is free to order an investigation or whatever matter it feels appropriate. Again, the same court can refuse. Any petition to the court is at the discretion of the court to either agree to it or to dismiss it. Another specific right of members is that of a petition to wind up. So members can decide to end a company's existence by special resolution. This is when probably a company is unable to pay its debts. A company is also, and by ordinary resolution, where a liquidator is appointed. So where members feel that it's no longer profitable to continue operating this company, they may petition to wind up business and then the company's existence. We also have the preemption rights. And these are the rights of existing ordinary shareholders to be offered new shares issued by the company pro rata to the existing holding of that class of shares. So these are specific rights that, again, do not hold as much weight as those general rights written down. And we go to the liability of members. The company, being a separate legal entity, means that the liability status is a shield, but it is not absolute. Because the extension of that liability shield can be both limited and disregarded. The limited liability protects the individual assets of the individual, and therefore the debts and claims against a company cannot be recovered by joining the members of the company. Remember, when we were talking about the difference between a sole proprietorship and a company, is that when I decide to form a company and I'm unable to pay my debts, then whatever I have acquired prior to even the thought of forming that company can be used to recover. But in the instance where this is a limited liability company, any member does not go into their personal assets to pay off the company's debts. But this limited liability shield can be determined to not extend to the acts or omissions of company members, or may be disregarded altogether. In any case, the court determines the liability shield. And a creditor, where the court determines that the liability has exceeded how much each member is supposed to pay up to that company, to the winding up. So there are three basic instances where a creditor or claimant may argue that the acts or an omission of their limited liability members prevents the liability shield from being extended to the member. And this is where a member acts on behalf of a limited liability company that has not yet been formed. We talked about promoters and the duties that we expect of them. So where the company is not in existence, then he is liable to pay up the debts that he has incurred. Number two, if the member acting as an agent of the company and without giving notice that he or she is acting on behalf of the company causes an injury that is recognized by law. So where you as a member decide to act on behalf of the company without informing the company that you're acting on behalf of them, then your action causes an injury, you will be personally liable for that. And thirdly, if the member acting as an agent of the company and without giving notice that you're acting on behalf of the company guarantees a contractual obligation, again, those actions that you deem to have entered on behalf of that company without giving notice that you're acting on that on behalf of the company, or without being given the express authority to act on behalf of the company, you are liable. So in these three instances, that shield is lifted and you are liable individually to pay up the debts that you have incurred on behalf of the company. So that is to the extent to which the liability of the members are.